All right. It's good to be in Atlanta. I made it through the snow today in Wyoming and got out just in time. So what are we going to talk about today? We're going to start with some policy issues at the state and federal level, and then look at some data about DPC practices across the country. And instead of thinking in sort of a defensive posture about what legal issues might come up, more of an offensive posture. I think that's more fun. So there those are for you. I think the HITECH piece is probably everybody's favorite who's heard any kind of discussions around these aims before. So let's start at the beginning. What is direct primary care? And this is sort of the easy three-part definition that the coalition at least typically uses when they're talking to one of the 25 states that still haven't passed a law. Charges a periodic fee. That's usually monthly, but it could be some other interval. It doesn't bill third parties on a fee-for-service basis, which is a way to distinguish direct primary care from concierge, because those practices have a monthly fee in addition to charging whoever's insurance company might be there. And then the third piece is, if they're going to charge you a per visit fee, they can do that, but if it's higher than the monthly fee, it's really not direct primary care. So you might envision a model where they charge $100 per visit and $10 per month. That's more of a discount urgent care setup than it is true DPC, where you have incentivized this ongoing relationship. This definition is not meant to be exclusive. So what's the point of this? It doesn't exclude a hybrid practice. There are some practices that see half their patients in DPC setting and half of them in the insured setting. We don't recommend that for legal and economical reasons in terms of overhead, but it's done. It's not meant to be exclusive. It's meant to protect the practices that need protecting. Why do they need protected? Because the state insurance commissioners get confused about this model, and they think that you're taking on too much risk and that you're operating an illegal insurance enterprise. So it doesn't imply illegality of other models either. I have no problem with concierge. I'm just not excited about what they do. Consider that an employer or state might pay the monthly fee. Is that ruled out by this definition? And the answer is no. As you'll see later, there are several states that are dabbling in direct primary care in a variety of settings, everything from Medicaid pilots to state employee pilots and what have you. And of course, it does distinguish DPC from concierge. I started aggregating different DPC practices across the country in a research study back in 2014 at the Robert Graham Center, and this was what the first map looked like. There were 125 locations that I was able to find. And as you'll see, that's increased over the years up to 290, and then up to 445, 620, and then now we're at 801. So there's been steady growth year over year, and practices keep increasing. What about legislation? What did that look like? Things started out a little bit rough. In 2006, Vic Wood, who was a graduate of my school, practiced in Wheeling, West Virginia, wound up with his own narrow law defining direct primary care. They didn't like what he was doing. The insurance commissioner threatened to shut down his practice. A bunch of patients complained and came to his defense. And he got a very narrow law passed that says he could basically stay in business, but they didn't want him to grow. So they had, their medical board had the approval to, or excuse me, their healthcare authority, which is the same entity that does their certificate of need, had the ability to approve his prices, approve his advertising. He couldn't advertise to anybody that wasn't already on a high deductible plan, etc. As you'll see, that law now has been repealed and replaced with something much nicer. 2007, we had a better bill in Washington State, and then we had a kind of dry period until 2011. Oregon looked to West Virginia for guidance instead of Washington, unfortunately. Both of those two states around the Pacific there, they have registration requirements that are sort of tedious and annoying, but fortunately nobody else of the 25 that we'll get to have followed in that model. Utah had a nice, concise, clean law. And then 2014, we had a lot of interesting action there. And Florida, you'll see, stayed blue for a while, and then finally this year we had some improvement. 2015, a whole lot of movement. This is, I think, everybody's talking about it more and more, and lots of states picked up on it. We had our first veto. That was the Montana governor, and his statements about DPC were rather entertaining. He clearly didn't know what it was, and that's why he vetoed it. It was that simple. Virginia, we had the same thing happen in 2016. As you can see, Florida kept trying and trying, but they stayed blue year after year. And they still didn't pass it in 2017 in Florida. We had another governor veto in Montana in 2017. It's the same guy, same reasons, same sad story there, even though they had a better law in 2017. And now we're up to 25 states that have DPC laws on the books, and we've got several more that are considering them this year. I've highlighted Montana now as purple rather than brown, and Massachusetts is actually in a purple category too. I wasn't using that in previous years. What's happened there is they had a insurance commissioner. They're one of the few states that elects their insurance commissioner, and he actually ran on part of this platform of fixing their approach to direct primary care. So he issued guidance that actually references lots of work that the coalition has done, basically saying, even though our governor's vetoing this, in my opinion, it's not insurance. And something similar has happened in Massachusetts. So 25 if you count the state laws up, 27 if you use the insurance commissioner guidance. There's a little bit of guidance in Maryland and South Carolina, but it's not quite as helpful as what's out there in Montana and Massachusetts. As far as where these other state laws are in blue, Pennsylvania and South Carolina probably look the most promising. I think they've made it through either the House or Senate in each respective state, and it's just a matter of getting it out of the opposite committee. Wisconsin and Maryland are probably less likely to move forward as they've not made it out of committee, and the state we're in now, Georgia, I don't think it's had much attention either, unfortunately. So if you want an overview, that is out there, and there is an open access way to get to that on DPC Frontier. It doesn't look at 2018 laws because it was a little bit dated by the time it was published, but it is there, and it's a helpful reference if you're going to pursue state legislation. The other thing you might see if you're reading news articles about direct primary care is more and more states are looking to see how they can save money from direct primary care. And there's a variety of ways they can try to do that. So the simplest are there in orange, and I'm probably missing a lot of orange states. Those are local municipalities that have a lot of autonomy, and what they're doing is they're saying, look, we've been on a self-insured policy for all of our employees, our 500 or 1,000 or what have you, for a long time. Why don't we bring a DPC doc on site and do that instead of paying all this insurance racket? And so they use that to minimize their downstream spend. Then you've got states that are on the other side of this where they make your life really difficult, and that would be Kentucky and Colorado. It doesn't matter what your status is with Medicaid in those states. It doesn't matter if you signed up. It doesn't matter if you never signed a contract with them, or if you used what's called opera status, where you've just signed up for ordering and referring only. You are not allowed to privately contract with Medicaid patients, full stop. The weird part about that in Kentucky is it's based on a prior governor's executive order, and Governor Bevin is not of the same opinion, but he hasn't yet changed it. In Colorado, it would require a change at the legislature level. And Colorado, ironically, is in the position of not allowing you to privately contract with any Medicaid patients for any purpose, but at the same time, they do have a state employee DPC pilot. So that's why I have the little purple block inside of a red Colorado there. Michigan passed a law authorizing a Medicaid DPC pilot, but none of it's been implemented yet. It's sort of been tabled. New Jersey is experimenting with it with their state employees. And then of the 3 states there that are proposing DPC legislation for Medicaid, or DPC coverage for Medicaid patients, Nebraska is probably the most promising. Wisconsin's in an awkward position. If you look at the last slide, we don't recommend this. They are also proposing a not insurance law. At the same time, they're proposing a Medicaid pilot. And if you think explaining DPC in the first place is not insurance is a little confusing, try doing it with the Medicaid pilot too. So I don't have high hopes that's going to pass their legislature this year. What are things doing at the federal level? We've been mentioning the HSA problem for a while now, and it has 2 problems. So 223C of the insurance code, of the tax code, states that if you have a plan, for you to be eligible to have a HSA, it has to be a high deductible plan. For an individual, I believe that's $1,300. So as long as it's more than that, you're good to go. But the IRS sees DPC, and they see a plan that's only covering primary care, and they argue that that plan is a $0 deductible because you don't get charged anything when you go in for a visit. So now they say, wait a minute, before you had an eligible plan, now you have 2 plans, and one of those plans is a gap plan with a $0 deductible. So we're going to claim that by joining a DPC practice, you can no longer contribute to an HSA. That's the first problem. The second problem is they don't view it as a qualified medical expense because they're used to seeing itemized things in a fee-for-service fashion. So they don't know what happened in there because they don't get a code. So they try to come at you and say, assuming you didn't even have that gap plan issue, the monthly fee that you're paying, you can't use your HSA card to do that. Now, in reality, what is happening? All over the country, people are using their HSAs to pay for DPC. The office doesn't necessarily know. They probably didn't give the patient guidance. And if the patient goes to an accountant, the accountant's going to make the logical conclusion that this is fine. But we do have guidance from the IRS that suggests they have this, in their mind, conservative view that you can't do it in this way. So we're trying to solve that problem. There are multiple pieces of federal legislation that address this issue. The best one is probably the Primary Care Enhancement Act, which is easy to remember. It's H.R. 365, at least the House number is easy to remember, or Senate Bill 1358. It does have bipartisan support. It's one of the few things in D.C. these days that does, but unfortunately it doesn't have enough dialogue, and for some reason D.C. is not into passing standalone bills right now. So there have been pieces of the Primary Care Enhancement Act that wound up in lots of other pieces of legislation, some of which are listed below there, and none of them, to my knowledge, are on the doorstep of being passed. There have been discussions about an executive order trying to address this, but we shall see. So what else are we going to cover today now that we've gone over the state and federal policy issues? We'll look at restrictive covenants, how to get out of them, when they might apply, when they might not. They're mostly used for intimidation. Leveraging your out-of-network status has already been covered pretty well by Andy, but we'll mention that some as well. Bypassing pharmacy benefit managers is probably my favorite piece, maybe that and HITECH. So, restrictive covenants or non-compete clauses, physicians would commonly refer to them, often show up in contracts of employment with a hospital system. Courts don't like these. Their bias is against them, and they're usually against public policy because it's anti-competitive. So, right off the bat, things are usually in your favor. There's a reasonableness test that they use where they value the business interest versus the hardship on you, the employee, and or the injury to the public, and that your patients may or may not be able to continue seeing you. And there's three requirements that they usually look at. They look at the business interest, they look at the geographical restriction, and they look at the time limit. So it's in the hospital system's interest to make these things as big and broad and mean as possible. And sometimes, depending on the state you're in, you might even look at that contract and just sign it because you've done your research and you know it's totally unenforceable. So you might see that geographic restriction and it might say 100 miles. And you might say, well, I've already got a case in here in this state that anything over 50 is invalidated. So don't bring it up and negotiate it down. Just let them leave it and they think they've got you and you've got them. So do your homework up front because they don't necessarily do theirs, especially when they operate in multiple states. But if it is enforceable and you want to, narrow it down, then of course you would do that. Since we're in Georgia, I figured I'd use Georgia as an example. They're one of the states that actually has a Restrictive Covenants Act on the books, and they discuss and define what a valid business interest is. A business interest would include something like confidential information that they didn't want to get out, maybe a trade secret, investment in your training, or customer-client relationships. So fortunately for physicians, generally speaking, by the time we're getting employed somewhere, our training is over. Obviously, we're doing ongoing CME and we're training ourselves, but we're not talking about a residency program here. What are the time limits that are expected in Georgia? It varies depending on your category of employee. So if you were a standard employee, it's 2 years. If you were a lessee in an operation, it's 3. If you were a seller, so if you sell your practice and have a non-compete, then they're going to be more severe with you, because that sounds like a more defined relationship where both parties truly came to a thorough understanding of what was going on. Geographic restrictions. In Georgia, at least, you're limited to 50 miles and or 10 counties. And what does the court do in terms of scrutiny with each different setup? There's a strict scrutiny that's applied to employment agreements. So if you were merely an employee, as you'll see back here, you got a 2-year time limit, and then they're going to apply strict scrutiny. So they're going to be harsher on the agreement and more likely to rule in your favor than if you were, say, a medical director, where there's mid-level scrutiny. So all these things are interesting to look at. They do vary quite a bit by state. So if we look at a state overview here, if you're in California, you don't have to worry about this. Montana, North Dakota, South Dakota, there's prohibited. End of discussion. So if somebody's got a non-compete with you there, don't worry about it. There are restrictive statutes. We just went over the Georgia example. There are several other states that sort of discuss that as well. And then there are states that have much more kind of obvious physician favoritism, and Texas is one of the examples that I've looked at in a little more detail. So when you're reviewing an employment contract, what else do you want to look at? Sort of briefly, there's an article in the AAPS journal on this as well. Look at your job description. The more detailed it is, that probably works in your favor. If they're vague on purpose. If they say other administrative duties as assigned, that could be a lot of work for not additional pay. And if you're thinking it's a 40-hour gig and they think it's an 80, well, then your salary's just been cut in half. So schedule, what does that look like? Same idea as above. Make sure you know what you're getting into. Moonlighting, you want to retain your option to do this. I think that's your best leverage. If you wind up not liking the position and you want to try another one, if you had the ability to moonlight, now you can do that. If you're not allowed to work anywhere else, then you're really stuck. Retain your research rights. If you come up with a new discovery, if you author a new paper, that's yours, not theirs. Malpractice tails, that's another way you can sort of get tagged. Remember, when you purchase malpractice, you can do it on a claims-made basis or an occurrence basis. And if you do it on a claims-made basis, that obligates you to buy a tail, because it means when you stop paying for the original policy, any lawsuit that comes for the past 2 years forward, you're going to have to need a tail to cover that. If it was occurrence-based, then that policy follows you going forward, even if you just retired, changed jobs, what have you. Okay. Network definitions. So these are things networks commonly define, and they get in our way in DPC and any other sort of cash pay medicine. They define what your fees are going to be, what your services should be. They try to have a say in your scope. They have a say in what's medically necessary or not necessary, and of course the terrible prior authorization process. The networks try to tell physicians what to do. They try to tell you who to refer to. They make it very easy to stay within the network and very difficult to go outside of it. They want you to provide medically necessary covered services and stick to the formulary. And the network shall, importantly there, have the right to inspect and duplicate all medical and billing records related to medical services rendered to covered members at no cost to the network. So they can kind of look through your stack of stuff anytime they want to. If you're out of network, they don't get to set your fees. They don't get to determine your scope. They don't get to make you do prior auths, at least if you listen to Dr. Greg Zidiak's discussion, which was an excellent talk at a prior AAPS event a few years ago. And they don't have the right to invade your patient's privacy. So if you're out of network, I would use that in your advertising. People are really worried about privacy these days. People are shutting down their Facebook accounts over privacy. I saw a story today that was highlighted where Facebook was trying to, group up with some hospital systems and use data and actually, in my opinion, find a way to, take it from de-identified to almost identified using algorithms and decide how to market to people. It was rather scary. So that really is a concern. It is a competitive advantage for you if you're in this space. If you're out of network, you can go public. You can embarrass the network. If you and your patient agree to talk about something they decline, you can go to the papers. If you'd sign an agreement with them, then you can't do those things. Does ERISA affect a DPC practice? If the employer is paying membership fees for the patient, whether it's 10 patients, 20 patients, 50 patients, 1,000 patients, then the answer is yes. So remember, under ERISA, if you get fired, if you quit your job, whatever, then you have the ability to continue funding your own insurance policy for, I believe, around as long as 18 months by paying the employer's share of that premium. And weirdly enough, even though it's not insurance, it can land under an ERISA plan. So if you were somebody who was seeing patients that were sponsored by the employer, you need to have the ability to let them continue to come to the practice in the event they're fired and they want to do so. ERISA has some immunity provisions that can be problematic. This applies to employer health benefit plans. So if the employer paid for it, it's under ERISA. And why does that matter? Typically, if a plan denies, let's say they deny a head CT, there was a terrible bleed, and there was a problematic outcome. You could go ahead and sue that plan for millions in damages. And if you're under a privately purchased plan, whether it be on the exchange or at the individual level, then you may well get millions in damages from that plan that caused the problem. If it's under ERISA, you're not going to get that. You're going to get you're limited to the recovery it limits your recovery to the value of the benefits provided in the plan. So the cost of the head CT, which is rather dramatic and silly, but that's been on the books a long time, and it's an immunity example. It's probably part of the reason those plans are cheaper as well. If you're a DPC physician and you want to dispense medications, where can you do it? If it's green, there's no problem. Some of these states have databases where you register, others don't. The vast majority, there's no registration and there's no fee or fine. Georgia, as an example, we'll come to next, and they actually have pretty good guidance. We've tried to get things changed in Texas. It did not happen. Montana, New Jersey, Massachusetts, I'm not aware of any efforts to overturn these laws. The pharmacy lobby, as you might imagine, gets really upset when we want to do that. Utah, they have a weird exception where you can dispense oncology meds, and you can dispense on-site if you're at a large employer, but if you have your own standalone office and you want to do something other than, I guess, methotrexate and cosmetics, then they're not going to let you dispense. It's rather bizarre. Georgia's dispensing, they actually have a nice guidance out. It's not harsh. It kind of gives you a rule book to follow. And even if you don't live in Georgia, it's a nice playbook to go by if you're sort of developing your own policy around dispensing and want to make yourself look good in the event of any audit. HITECH. Think of this as your cash pay for privacy provision. So HITECH modified HIPAA several years ago, and it set forth circumstances in which a covered entity now must, keyword, comply with an individual's request for restriction of disclosure of his or her protected health information. So, if your patient wants, even if you're in the system, even if you're contemplating DPC and you're doing everything, traditional medicine at this point, a patient can walk in your office and demand that you not bill their insurance. They can say it's for privacy reasons, and it doesn't have to be something embarrassing. It could be anything they want it to be. It could be for their asthma and their albuterol. The covered entity must agree to the requested restriction unless the disclosure is otherwise required by law, so we'll get to that later. And so, for the purposes of carrying out payment, you basically, what happens is they demand privacy. You say, okay, fine, I have to give you privacy, so now I give you privacy, and the patient pays cash instead of running it through the insurance plan. And this follows throughout the chain of the health system. So if you were going to electronically prescribe things at CVS, then you need to make sure that stays private too. So you're probably going back to a handwritten prescription so that they can walk it up to CVS and have the same conversation with them and not run it through the plan. What are the exceptions? So HITECH said, unfortunately, in the event this phrase conflicts with another law, the other law wins. So what might those other laws be? Well, Kentucky and Colorado are obvious Medicaid exceptions. Medicaid would trump HITECH. If a state had an HMO law that was overly restrictive, and to my knowledge most of them don't, that would also conflict with HITECH, and the patient would not have a right to use this privacy provision to get a cash pay price. What about Medicare? Medicare went ahead and addressed this. Believe it or not, they thought about this and they said, okay, this makes logical sense. If a Medicare patient wants to have a cash pay price, they can do it. So this is the one time where you, even as a participating physician in Medicare, you can privately charge a patient. Now you're going to charge them the same fee that you would have charged Medicare. You don't have freedom to set that price. But if the patient elects it for privacy purposes, then they're allowed to pay you. Okay. So implementation, how do you physically go about doing this? You're going to have them sign a request that they wanted this privacy provision and they wanted to pay privately. And you're going to flag this so that it's not accidentally shared with the health plan down the road. If you put this in your medical record, in your regular chart and counter notes, and then 6 months from now somebody asks for this record and you accidentally send it, then you violated their privacy request. So you need to be able to break off that information and keep it in a different file. And then, of course, the downstream issue we mentioned earlier, it's kind of tricky, but the patient has to keep making this request over and over. There's not an easy mechanism to do that in our current electronic prescribing system. So in summary, what does HITECH really have you doing? All covered entities must have a process. So if you're under HIPAA, then HITECH applies to you and you have to have this ability for the patient to do this. Medicare, we talked about, there is a way to do it. Medicaid, not really. HMOs are usually not a problem, but you have to look and see how restrictively they're written. And the fun part, of course, is at the bottom. I've saved that for last. Who wins over federal law or private contract? Federal law. So insurance companies over and over and over are going to say you can't do this, and look, obviously you can. It just invalidates that portion of their agreement. It doesn't matter if they say that you can't accept private payment. Under HITECH, you can if the patient makes that request. Okay. So I kind of jumped ahead on this one, but in terms of opt-out implications, somebody might take what I just said to the extreme and say, well, what if all my patients always request privacy? Then I just don't have to opt out and I can just charge all them and never charge Medicare. I think that'd be a hard practice to defend because probably not everybody coming at you wants that level of privacy, so I wouldn't take that approach. Transparent consults. That's another thing that's important in direct primary care. We want to find ways for our patients to continue seeing physicians on a cash pay basis outside of our practice. And while you can rely on HITECH, it's not usually a fun way to go about it, and it doesn't necessarily get you a good price. So beyond educating consultants about that, try to actually get them to maybe do a telemed visit with you, especially if it's not an exam-intensive consult. Then there's no confusion at all because you have two physicians in the room with the patient, which is a really rare thing these days. And it gets your answers to questions in a much quicker fashion. If you have opted out, which Dr. Huntoon went into in great detail, where else can you work? What about things outside of your DPC practice? There are lots of different opportunities. Occupational medicine is a separate state-based insurance system. Some states it's good, others it's less helpful, but it's always an option. Urgent care and emergency care, there's an exception, which we'll come to in a minute. Cash pay telemedicine, hospice administration, or the three I've highlighted there are kind of my bias and my favorites because they're pretty close to DPC, and it's always nice to moonlight as a DPC physician in a DPC manner, and that's about as close as you can get. So what are the differences there? If you're doing correctional medicine or some sort of on-site DPC clinic or even the PACE program, which is actually often a Medicare, Medicaid dual eligible where there's a monthly fee and there's no coding obligation. It's been around for 20 years, but most people haven't heard of it. Then you still have some problems because the patient's not paying the fee and they may have less of a choice of physician, but all those green things are the same. So you get a lot of what you wanted out of a DPC practice even in these other different settings. So what does the urgent and emergency exception amount to? As Dr. Huntoon mentioned, you cannot sign a contract under duress and expect it to be enforceable. So if a patient comes in and they have chest pain, you do an EKG and there's a STEMI, that's not a good time to go over the provisions of your private contract. They've got other things on their mind, and it would not be enforceable. But what you could do is you could charge them at the Medicare rates, actually it's slightly below, I believe it's at the non-participating physician rate, and use a separate code, and then you can still get paid, even in the event you've opted out. Now, if this were your own DPC patient and you already had a private contract in place where you and they promised not to bill Medicare, then you're not charging them for this. That's already included in your DPC fee anyway, I would argue, but you can't charge in those situations. But the most common question would be, if I'm opted out and I have a private practice in town and I want to do some moonlighting in the ER, can I do that? And the answer is yes. Can the ER get paid for what you do for Medicare patients? The answer is yes. They get paid at 95% in terms of physician billing. Everything you order downstream, all those CT scans, all those central lines that you place, they get paid their usual rate. That doesn't even affect those rates. The only issue you might have is if you're in a really small town and somebody comes in and you already have a private contract, then for your portion of those services, you're simply not going to bill. So hopefully I didn't run over too much. If you have any questions, there's my email.